Hello, everybody. My name is Catherine Coulter. I'd like to welcome you all to today's webinar on corporate and employment considerations across venture financing rounds. I am the group lead of our Denton's Ottawa Employment Group, and I'm going to be moderating today's discussion on a topic that we see play out time and time again with our venture-backed clients. Namely how your corporate and employment law obligations evolve and become significantly more complex as your company moves through successive rounds of financing. I am really happy to be joined today by three of my terrific colleagues. We've got Sean Del Giallo, Heather Bunnell, and Maggie Sullivan. And I'm going to introduce them before we get started because we're going to do this as a little bit of a round table, if you will, rather than a typical presentation. I love fun facts. I like to know more about my colleagues, and I'm sure that you like to know more about the people who are speaking to you. And so I forced everybody under threat that they had to provide me with some fun facts. And so here we go. Not a fun fact, but Sean Del Giallo is a partner in our corporate and venture technology and emerging growth companies group, and he's the Ottawa leader of the securities and corporate finance team. For his fun fact, Sean played drums in a metal band in high school, which I actually believe, and took a month off in his senior year to tour Ontario and the Maritimes. He became a lawyer, so read into that what you will. As well, Ace, as we all call him now, made a hole-in-one last week at the Ottawa Tech Open. I'm told it wasn't mini putt. I have my doubts, but he has shown us all a photo. Heather Bunnell is a senior associate in our corporate securities, corporate finance, and venture technology and emerging growth companies group. Heather says that she loves marathons, but specifically, she said that she loves watching marathons. While she doesn't expect that she'll ever run in one, she has some very fast friends that she likes to cheer on. And as well, Heather has been learning pottery on a pottery wheel over the last couple of years and tells me that she has successfully made some mugs. And finally, last but not least, Maggie Sullivan is an associate in our employment group. She has considerable expertise working with startups and early stage technology companies in particular. Maggie is in the process of filming her audition video to be on Survivor, and her next step is apparently taking swimming lessons so that she can be a challenge beast, as she calls herself. I would have thought that surviving the practice of law would be enough, but Maggie's a rugby playing athlete and she's always up for a challenge, and so she's set herself a new one. Together, the three speakers are going to walk us through the key considerations at each stage of a company's growth, from pre-seed through to Series C, with Sean and Heather covering the corporate side of things and Maggie addressing the employment law side. We're going to move through several stages here: pre-seed, seed, Series A, B, and C. And at each stage, I'm going to pose questions to each of our panelists, and then we'll close with some takeaways from all of our speakers and move to the Q&A if we have some time. And so without further ado, I'd like to get started. We're going to start at the very beginning, pre-seed, and I would ask that all of our speakers jump on at this point in time. The company might be nothing more than 2 or 3 founders at the pre-seed stage, and they have an idea. Maybe they're working out of the proverbial garage, and they probably have minimal external capital. And so, Heather, from a corporate perspective, what should founders be thinking about at this stage?
Thanks, Catherine. So yeah, as you noted, at the pre-seed stage, the company is usually just a small group of people who've maybe spent some time and effort developing a business, but typically the company wouldn't have accepted any investments and may even be unincorporated. So the decisions that the founders make at this very early stage can often be the ones that they are still dealing with or are trying to unwind years later when they're doing diligence for a Series A. And so it's an important time to get your company organized well from a corporate perspective. In fact, there are a lot of things that we would recommend companies do at this stage, and we'll cover the minimums we suggest at this time. But ultimately, you'll want to find legal counsel that understands and is experienced working with high growth and scalable companies, because the way you set yourself up at the pre-stage stage will you can leverage as you move to further financing. So, at a minimum, at the pre-seed stage, companies will want to incorporate, issue shares to the founder team, enter into a shareholder agreement, and then also make sure that they're assigning intellectual property to the company. If a pre-seed company has accepted or wants to accept any outside capital, it will also need to consider the structure and securities it will issue in exchange for that capital, which Sean will discuss shortly. So, in the meantime, first, for capital structure, and by that I mean the class and series of shares that the company is authorized to issue, the rights attaching to those shares, and the total number of shares available, that is entirely customizable, as is the initial shareholdings that will be issued to founders. However, we always recommend keeping it simple at this stage. We typically incorporate companies with just voting common shares and non-voting common shares, with the voting common shares issued to the founding team for a nominal amount. Founders might split their initial shareholdings equally, or they can come up with an allocation on a predetermined basis. For example, if one founder is spending more time on the company, they may take 50% of the initial shares, with the remaining founders dividing up the rest. The important part to note here, though, is that the company's capital structure will evolve as the company grows and as it moves through the stages that we'll talk about today. So at the outset, it should be simple with a clear allocation amongst the founding shareholders. We also really recommend that that allocation is in writing. We often see companies come to us years later with initial shareholdings that they never got around to papering, which is fine if the founding team is still working well together. However, if everyone has an idea of what the allocations were at the beginning, but they never got around to putting it into writing, that could cause issues down the line, which we always want to avoid. So, also, if there's more than one shareholder, it's essential for the company and shareholders to sign a shareholders agreement. This agreement will govern the relationship between the shareholders and the company, which at a minimum should address decision-making authority, share transfer restrictions, requirements for share sales, and preemptive rights. It can also address vesting schedules and the company's right to repurchase shares upon certain triggering events. Pre-seed is also the stage where a company needs to ensure the idea behind the business is actually owned by the business. And we recommend that founders sign IP assignments, intellectual property assignments, to make sure that the company actually owns what the business is being, the intellectual property on which the business is being developed, and the founders don't hold that IP personally. So every founder and early contractor or developer who touches the intellectual property of the company should sign an IP assignment agreement that vests all of their work product in the company, and it waives or assigns all related IP. This is something that will come up in diligence as the company moves through its fundraising stages, and any gaps in IP ownership can be deal killers, especially if you have a founder that started really early and leaves. It can be harder to track down later on. Finally, at the pre-seed stage, founders need to just get disciplined ultimately about corporate formalities, maintaining a minute book, passing proper director and shareholder resolutions. It makes it much easier to raise capital if you have your corporate house well organized, because missing items can be expensive and embarrassing down the line when you're doing diligence.
Thanks, Heather. It sounds like there's a lot there for a company that's at the pre-seed stage. I think probably more than folks who are getting together, batting around an idea would understand. Maggie, what's the case on the employment front at this point?
Thank you, Catherine. So at pre-seed, the first issue I would flag is to document the founder's own working arrangements with the company. So Heather mentioned the shareholding arrangement and the shareholders agreement, which is essential. But from an employment law perspective, founders also need to document their working relationship with the company. More often than not, founders are also employees. Founders are generally putting all of their time and attention into the business. They're working full-time hours and exclusively for their company. They're a key representative of their company, and they're overall critical to the success of the business. Founders may also assign themselves a title such as Chief Executive Officer, Chief Technology Officer, and truly they are an employee that is servicing the company. Therefore, an employment agreement between each founder and the company ought to be entered into. This means that the founder will need to be paid a salary, as well as be provided with the various rights and entitlements that come along with being an employee, such as vacation and termination rights. However, since most startup companies are generally unprofitable in their early years, we understand that this may not be desirable. Every dollar is generally going into the business, and the founders may be prepared to wait for the delayed gratification that will come with the success of their business and forego any compensation in these early stages. However, even if no employment agreement is entered into, this would not change the fact that the founder is still an employee if the nature of the relationship proves it so. Therefore, by failing to put an employment agreement in place, the founder can be putting the company at risk. Among other things, this can represent a concern for potential investors. Well-drafted agreements show investors that expectations on and of the founders are clear, that employment risks have been assessed and addressed, and that there's a foundation for moving through future transitions. That said, if paying the founder is truly not viable, an alternative may be for the founder to enter into a contractor agreement. Now, this comes with its own risks, as employees and contractors are two legally distinct types of workers, and there can be consequences with classifying someone as a contractor when they are truly an employee. And this is a topic that deserves a presentation in its own right, and I've actually done one before in the past. But very briefly, in terms of what the distinction between the two is whether a worker is an employee or an independent contractor. It depends on several factors, including the degree of control exercised by the business, the level of integration of the person into the essential functions and management of the business, whether the person has a job title and signing authority, and whether there's this expectation of exclusivity, among many other factors. And I'll comment just briefly that misclassification can result in liability for the company, including for unpaid income taxes and other withholdings, unpaid statutory obligations, as well as potential fines and penalties. But notwithstanding all of that, with a contractor arrangement, founders can enter into an agreement with the company where they don't need to be paid minimum wage. They could potentially be paid a smaller stipend, or we could even put together an arrangement where they're compensated solely via equity. And while this may not be perfect, employment agreement is usually the way to go. Investors more often than not would rather see some agreement in place as opposed to none at all. And with that, I'll turn it back to you, Catherine.
Thanks, Maggie. So I think the message at pre-seed is pretty clear. You've got to document everything. In a perfect world, you're going to have a corporate structure, you're going to have founder relationships, and you're going to document every working relationship as well, even if it feels premature, even if there isn't money to pay anyone, even if you don't have an office space, even if the only people working for the organization are actually the founders. What happens when we get to pre-seed financing? Sean?
Thanks, Catherine. Yeah, so once the company is fully set up and founders are embarking on a fundraising experience, you open up your pre-seed investment round. And at this stage, the structure of that investment round is probably your primary consideration. Company might be pre-revenue. A lot of the value might be in the intangibles, and so the founders and investors alike might not see eye to eye on what the company's worth at that stage. So a lot of times at pre-seed, you'll see companies issuing securities convertible into shares at a later date, which gives the benefit of punting that valuation discussion down the road until your first price round. So two of the most common instruments you typically see at this stage are safes or simple agreements for future equity, or convertible notes or convertible debentures. Both types of instruments serve similar economic purpose, but they're meaningfully different in structure. So the choice between them matters. So what are those differences? So the primary difference is that convertible notes have a maturity date and safes don't. So safes give the investor the right to receive equity in a future priced round on a liquidity event if the company goes insolvent or dissolves. without a maturity date or without interest accruing. The standard form of SAFE was actually developed by Y Combinator, and it's become extremely common both in the US and Canadian venture ecosystem. From a founder's perspective, these documents are more simple, typically 5 pages, 7 pages. They're cleaner. They're more preferable from a cost perspective because there's less to negotiate given the standardized form. From an investor's perspective, they're also very straightforward, easier to negotiate due to the standardized form. Although some earlier stage investors might push back on the safe structure because it can be seen as a riskier investment than the convertible debt route due to the lack of maturity date and investors being concerned about being what we would call sometimes a stuck holder, where you're locked up in a safe. There's no real viable path to becoming an actual shareholder until one of these triggering events occurs, and that might never come to fruition. So the convertible note, by contrast, typically does carry an interest rate, although it doesn't have to, but it always has a maturity date. And if the company hasn't converted the note or repaid the note by that maturity date, the note holder usually has a right to demand repayment. Sometimes they can become automatically or optionally convertible at maturity, which might be a way to bridge a negotiation, but typically it's repayable at that point. So in practice, despite what the form of note might say, most convertible notes at the pre-seed stage aren't actually repaid in cash. They're intended to convert into equity, and most investors participating in this type of investment want to become a shareholder at some point at a beneficial price. So the debt characterization does create real legal obligations because it's always something an investor could fall back on if things aren't going well, or they don't see the same path to a return that they may have seen at the time of the initial investment. The other considerations are that interest typically continues to accrue until the repayment or conversion. That maturity date does create a deadline for the company to make a decision. So if the company's struggling and a price round hasn't materialized, the founder might find themselves in a difficult position or having to entertain difficult discussions with their earliest supporters. Convertible notes also can be highly customized. So that can include the types of events that trigger conversion. There might be different types of qualified financings, non-qualified financings, other events that can trigger conversion at the option of the holder or automatically. The notes might be secured or they might be unsecured, which affects the liquidity stack in an insolvency scenario. And then the types of representations, warranties, and covenants are highly customizable on these types of investment vehicles. So those are the major differences. What makes them similar is that both instruments typically include two economic features that incentivize investors to get in before that price round. So the first is what's known as a valuation cap. So a valuation cap isn't a valuation, it's actually a ceiling on the company valuation at which the convertible security will convert into equity. The second is what's known as a discount rate, which gives the converting investor the right to purchase shares at a percentage discount to the price paid by new investors, for example, at the time of the first price round. So to kind of demonstrate how these play out, a safe, let's say, that has a 5 million valuation cap, might convert into a company's Series A round. And let's say the Series A round's priced at a 20 million valuation. So in that scenario, that safe holder converts as though the company's valuation was actually 5 million, meaning that they get significantly more shares per dollar invested than the new Series A investors. So that's the incentive to get those investors in early on the safe. Now, if the Series A round was priced at below that 5 million valuation cap and the SAFE was cap only, then in that scenario, the SAFE would convert into shares at the same per dollar amount invested as the new investors. So to prevent against this from an investor standpoint, they might want a discount rate instead. So the conversion price with a discounted SAFE or a discounted convertible note is simply the price per share determined at that priced round or on a liquidity event, reduced by the agreed discount. So market standard these days, we're typically seeing anywhere between 10 to 30%, 20% is very common. And it's possible that an instrument can have both the cap and the discount so that the holder converts at whichever price is more favorable to them. Few other items I'd specifically flag for Canadian founders when they're raising at that pre-seed stage. First is securities law compliance. So whether you're issuing safes or convertible notes, those both represent a distribution of securities under Canadian securities legislation. So that means you need to rely on a prospectus exemption. The most commonly used prospectus exemption at pre-seed stage is typically the private issuer exemption or the accredited investor exemption under National Instrument 45106. So that means your investors, if you're relying on the private issuer exemption, need to either be insiders, close friends or family, or they otherwise need to meet the financial thresholds that qualify them as accredited investors. On top of that, the company needs to be collecting the right documentation to support that reliance. This isn't an area to improvise on, and it's one of the most important reasons you might want to engage legal counsel to advise on a structure that might otherwise seem as simple as a SAFE, because securities law violations at the early stage can create ongoing problems for future financings. They can result in hefty fines, and they can expose the company to liability from unsophisticated investors later on. Second, if you do have US investors participating in your round, you also need to think about US securities law compliance in parallel. So these include Regulation D filings at the federal level. At the time of your first investment round, you would need to create an Edgar profile to be eligible to make that Form D filing. And then there might also be state level filing requirements on top of that, depending on which states those US investors are originating from. So your legal advisors on both sides of the border need to be coordinating to ensure this is completed within the relevant deadlines after you close. Otherwise, late fees can be assessed and charged to your company, and those late fees can continue to accrue over time until those documents are filed. And then third, keep your cap table documentation clean from the moment you issue your first instrument. So every SAFE, every convertible note, any warrant, if there are any, need to be tracked, because when you do get to a priced round, your investors and their counsel are going to want a fully diluted cap table that accounts for everything that's been issued in the company to date. Reconstructing that history under the time pressure of a future round is not where you want to be, especially if it delays signing of a term sheet. So I always recommend that founders have their CFO, accountant, or even lawyers can do this, model out cap table scenarios reflecting the dilutive effect to shareholders once your SAFE or convertible notes have converted, because you don't want this to come as a surprise at your first priced round. So after you've already issued SAFEs or convertible notes, that's not the time to understand how that will affect you in various priced round scenarios. So a big example is it's actually mathematically possible to raise too much money on a SAFE or a convertible note with a valuation cap, because the way those conversion mechanics work is that if you raised more than what the valuation cap represents, you could have actually been contractually obligated to give away more than 100% of your company. So given this, even if you think you understand the basic conversion mechanisms in these instruments, It's always a good idea to model out a few scenarios before you issue your first safe or convertible note. That way you clearly understand the dilutive effect at the time of conversion before you settle on terms. Back over to you, Catherine.
Thanks, Sean. There's a lot there. And we haven't even hit seed financing yet. So we're going to move on to the seed stage. And my understanding is that at that point in time, the company is typically securing its first institutional investment, perhaps a VC fund focused on early stage companies, maybe an accelerator. And the company is probably also going to be making its first hirings at this point in time beyond the founding team. Heather, what does a seed stage financing typically entail?
Yeah, so seed financing is a fairly transformative event in the company's corporate journey. It's typically the first time that the company will sell shares to outside investors, typically early stage venture funds. And they will do real diligence on the company's corporate records and general legal compliance. So that will, of course, include the securities law compliance points that Sean just mentioned, as well as the employment matters that Maggie was talking about in the pre-seed stage as well. And then in addition, corporate governance is no longer left to the founders. Seed level investors will want a board seat, sort of a seat at the table. And so the governance of the corporation moving forward will shift. The financing itself will be based on an agreed valuation between the investors and the company, which will be used to determine the price of the shares that they will sell, which is why it's referred to as a priced round. The priced round itself will involve a detailed set of transaction documents. Primarily, those will be the subscription agreement, which will address the sale of the shares, articles of amendment, which will set out the share terms of the new shares that will be created and sold, and the renegotiation of the shareholders' agreements. So this is fairly standardized in Canada and the US with respect to the shareholders agreement. The single shareholders agreement that we would have put in place at the pre-seed stage is replaced with 3 distinct shareholders agreements. Those are known as the investors' rights agreements, a voting agreement, and a right of first refusal and co-sale agreement that sort of act together to cover the same sorts of terms that were in your pre-seed shareholders agreement, such as share transfer restrictions, requirements for share sales, preemptive rights, etc. But the seed investors will also negotiate new protective provisions, which are essentially veto rights over certain corporate actions that they want to have a say over. So those can be issuing new equity financing rounds, incurring debt, or selling the company. And then, as I mentioned as well, they typically, seed stage investors will typically ask for a seat on the board, enhanced information rights, and anti-dilution protections. The company will issue, as I mentioned, a new class of shares. So the articles will be amended and a new class of preferred shares will be created. They're typically called the seed preferred shares. And the terms attached to those shares, which will include liquidation preferences, participation rights, conversion mechanics, and anti-dilution protection, will have a significant impact on the founders' economics. The terms, as I said, will be set out in the articles of amendment. And so notably, every series of preferred shares that gets created will not only dilute the founders' common shares, they will carry a liquidation preference, which is typically referred to as a 1x preference or a 1 times preference, meaning that those investors will get their money back at a liquidity event before any proceeds flow to the common shareholders. And so they sit on top of what's called a waterfall or a liquidation stack. A simple illustrative example would be that if seed investors put in $3 million, so their 1x would be $3 million back, and the company later sells for 3.5 million, the preferred holders receive their 3 million off the top, with only 500K left to divide amongst the common shareholders. It's not a very common scenario, but just for illustrative purposes, that's what's called the waterfall or liquidation stack. However, at the time of a liquidity event, investors don't automatically take their 1x preference. Instead, they typically have a choice, and these are the terms that are set out in the articles. They can either take the liquidation preference or they can convert their preferred shares into common shares and participate in the proceeds on an as converted basis alongside the common shareholders. And they will just choose whatever results in the most amount of proceeds. So in a modest exit, the preference will typically be chosen. Investors take their money back off the top rather than converting, but in a large exit, the as converted value can significantly exceed the 1x preference, and investors will elect to convert instead. So again, using our very simple example for illustrative purposes, if the seed investors put in 3 million, but on an as converted basis, their shares represent 20% of the company and the company sells for 50 million, that as converted 20% entitlement is $10 million, which is well in excess of their 3 million preference. So they would convert. So in that scenario, preferred and common shareholders are all participating pro rata in the proceeds, and the waterfall dynamic effectively disappears. Now, they're similar to what we were talking about earlier. There are a lot of different considerations and ways that this can flow depending on the terms that are negotiated. But for illustrative purposes, that's essentially the basics. And then again, the seed financing will also typically trigger the conversion of any outstanding convertible notes. So or instruments. So the notes or the safes that are outstanding will convert into shares. You will see the dilutive impact of those, as Sean discussed earlier. And the aggregate effect of a seed financing on the company's cap table and the founder's ownership of the shares of the company really can meaningfully change at this stage. Yeah, so with that, I'll pass it over to Catherine.
Thanks, Heather. Maggie, what's going to happen at this point in time from an employment law point of view? You're now in seed financing. I assume there are other obligations now on the company vis-a-vis the employees. So what do those look like?
You are exactly right. There are a number of obligations that come up at this stage. First, I'll mention that just as it's important to do so with the founders, it's essential to clearly document every employment relationship with new hires going forward. The agreement should cover all the essentials: job title, salary, hours, vacation, termination provisions, etc. I would like to draw particular emphasis to the termination provisions. In Ontario and most other provinces in Canada, unless you contractually limit an employee's termination entitlements, they'll be entitled to what's called common law reasonable notice, which can entitle the employee to about 1 to 2 months of compensation per year of service when they're terminated without cause. And this is generally significantly more than what they would be entitled to under statute, which is about 1 week of notice per year of service. So a well-drafted termination clause in your employment agreements that limits termination entitlements to statutory minimums can save the company significant money down the line. And this is something investors will always want to see. And if it's not done right, will usually need to be addressed at each financing stage. In addition to written agreements with the workers, companies at the seed stage will need to start documenting and maintaining workplace policies. Generally, all companies with employees in Ontario need to have and maintain a workplace harassment policy, a workplace violence policy, an occupational health and safety policy, and an accessibility policy. And these policies are generally required once the company has even just one worker. And while some of them don't necessarily need to be deduced to writing until there are 5 or sometimes more employees regularly employed, investors will often want to see these policies to ensure that a company is aware of and engaged in its obligations as an employer. And in tandem with implementing these policies, companies need to train their employees on the policies and the obligations under them. And this is mandatory. Training your employees on these is mandatory. For some of the topics, occupational health and safety in particular, there are mandated training programs issued by the Ministry of Labor that must be completed. But where there's not a mandatory program, it's up to the employer to make sure that adequate training is put together, or an employer can go in and purchase access to training models by third-party providers. On health and safety specifically, I'd also like to mention other obligations that arise early on. Specifically, once a company has at least 5 employees regularly employed, it needs to appoint a health and safety representative who will be responsible for a number of duties outlined in the Occupational Health and Safety Act, all generally designed to oversee the company's safety compliance and ensure that it is meeting different safety obligations. In addition to the health and safety representative, a company will need to consider what first aid materials and first aid training is required, as well as what hazardous materials training might be required. And as I'm sure you can imagine, safety risks will vary depending on the nature of your business. But even for businesses that are just creating software, operating in a business, safety should still be top of mind, and this should be starting early on. So we have agreements, policies, training, and with that foundation in place, the company should be ensuring that it's abiding by employment standards legislation at large. And this includes abiding by job posting obligations, recruitment obligations, holiday pay, overtime pay, vacation pay, leaves of absence, and I could truly go on and on. But I'd like to flag vacation pay in particular. Vacation is a particularly complex area of the law. And because of this complexity, it is something that many companies get wrong. And because of this, it's important for companies to work with employment counsel early to get a handle on their vacation pay obligations. And the reason I emphasize this is because vacation pay is a form of wages. And therefore, if a company is not handling vacation correctly, it can be accumulating a significant unpaid wages liability through unpaid vacation pay. And while a company itself is liable for unpaid wages claims, the director of a corporation, or the directors, I should say, can also be held jointly and severally liable for unpaid wages claims on a personal basis. And Heather and Sean mentioned that institutional investors will often want a seat on the board. And so when they're doing their due diligence in a financing round and they see this unpaid wages liability, it can be a major red flag in their inclination to invest in the company. And as a final comment, I'll also flag equity promises, which Heather and Sean have talked about a number of different instruments in that regard. Heather mentioned, or Sean mentioned, tracking the cap table. And from my side, or the employment law side, any promises of equity to employees should simply be clearly documented. Vague promises of a stake in the company is just a recipe for disaster and future dispute. And so, if options are planned, contractual provisions should be included in the applicable agreements, and the foundation for a formal stock option plan should begin now.
Thanks, Maggie. Yeah, if I can just reiterate, on my with my number of years of practice and working closely with Heather and Sean and the rest of our corporate venture tech and emerging growth teams, I can't emphasize enough how often we see huge catch-up issues required by employers on the employment law side when they get into the seed stage and beyond. Employment agreements, it's critical that they be drafted properly, and they really need to be drafted by an employment lawyer. You can't wing it. You can't take things off the internet. That just gets you into trouble. And there are a whole host of legislative requirements in every province in Canada for employers. Maggie spent some time on vacation pay, but you name it, we've got it. Statutory leaves, overtime. There are exemptions to some of these things. Occupational health and safety, workplace safety and insurance, accessibility, pay equity. We'll talk more about those things in the autumn in our next webinar. But best to get a start on them earlier rather than later because they are all potential liability issues for employers on the employment law side. Going back to where you finished off, Maggie, on the equity side, how do the corporate and employment considerations around equity intersect at the seed stage?
Yeah, so like Maggie said, it'll be important to create a formal stock option plan, either at the seed stage or even the pre-seed stage. Investors will certainly expect to see it if it's not already in place. And essentially, a stock option plan will formalize a process whereby you can grant employees, consultants, directors with the option to purchase shares at a future date. So they and with that comes a set price. And so stock options give employees the right to purchase shares at a fixed exercise price, or often it's called a strike price, which is set at the time that the option is granted. So the idea being that if the company grows in value, the option holder can later exercise their options and buy shares at a price that was set previously and is in theory lower than what the shares would sell for when they exercise. So they can realize the difference as a gain. And this also allows employees to participate in the upside of a company, particularly at a liquidity event. So the goal is to incentivize employees while also protecting the company's equity reasonably and retaining employees and consultants. And so typically options vest over time. A standard vesting schedule would be over a 4-year period, typically with a 1-year cliff, which means that an employee may be granted 100 options today, and they have to continue to work at the company for a year before they can exercise any of those options. And so that's the cliff. So over a year, nothing vests. Thereafter, 25% of the options, so 25, if they had 100 options granted, 25 would vest when they hit their 1-year anniversary, and thereafter, the remaining 75% of the options would vest either monthly or quarterly over the next 3 years. If an employee leaves before the cliff, before the 1-year mark is hit, they would forfeit those options. And then after the cliff, only vested options are exercisable if they were to leave. Most plans impose a short exercise window after an employee departs, whether they're let go or they choose to leave, and after which all options are canceled and they return to the pool. There are also special tax rules in Canada, which I won't get into, but that can lead to favorable tax treatment on exercise of options, particularly if the company is a Canadian-controlled private company or CCPC. So a few key points on how these plans work and how to plan them out. First is the option pool, meaning the total number of shares that are reserved for grants under the plan is typically 10 to 15% of the fully diluted equity of the company. And typically the shares on offer under an option plan are common shares, either voting or non-voting. The exact size will depend on negotiations between the founders and the seed investors. But the 10 to 15% is sort of a reasonable starting point. The plan should be administered by the board of directors, not management, to avoid any conflicts of interest, because this is also a good tool to incentivize high-level management as well as rank and file employees. And so the plan should also include flexible provisions for how options are treated on a sale of the company. That gives the company flexibility when they're dealing with an M&A transaction. For example, vesting can be accelerated in connection with a sale of the company. That's something that we commonly see. And so the idea being is not to have very rigid plan language and allow the board a fair amount of discretion in how to administrate the options in various circumstances. And so again, this is something that you don't want to wing it or pull something off the internet. There's quite a lot to it, and involves sort of a coordination between the employment team and the corporate team. Oh, I think you might be on mute there, Catherine.
I'm sorry. Thanks, Heather. If I can just briefly speak to that on the coordination with the employment team side of things. We have been speaking, and I spoke at our April National Employment Law webinar on some of the employment issues inherent within stock option and related equity plans. We're going to be talking about this more as we get into the summer. There's currently a large case in front of that was heard by the Ontario Court of Appeal. Recently, we're awaiting a decision, and the nub of it comes down to, do you interpret these equity plans as providing employee type rights, which should be governed by employment law, or should they be governed by corporate law because they're really corporate documents, even though individuals are often receiving the equity in the course of employment? And that's an oversimplification, but it's a big unknown right now. And as a result, there are a lot of things that we need to think about when these equity plans are drafted. And as Heather said, we work very closely together when it comes to these sorts of documents. Moving on then, we're now into our series financing. So Series A and B, headcount. Your headcount is going to be growing at this point in time, probably from about 15 or so employees to 50, maybe even to 100 plus. Your company is going to be becoming more professional. You're probably going to be hiring specific people at or about the C-suite level to help you with operations and finance and human resources, perhaps even a chief legal officer. Let's start with you, Maggie, this time. What happens on the employment side at this point?
Thank you, Catherine. So as a company grows, it's inevitable that more obligations will come into frame. And I already mentioned certain policies that are mandatory even when there's only a handful of employees. But in addition, in Ontario, once a company has 25 or more employees regularly employed, then it also needs to have and maintain a disconnecting from work policy and an electronic monitoring policy. So these two can also be added to the proverbial checklist of things to happen. And I'll note as an aside that we do have a very useful checklist that we can give to our clients that outlines all of these policies and a number of the employment obligations on companies in Ontario. With that said, it might also be necessary for the company to implement certain non-mandatory policies. The company may want to or find it necessary to implement a human rights and diversity policy, a computer and device use policy, a code of conduct, a remote work policy, a social media policy, and I can similarly go on and on. A number of these policies are indeed recommended, and you don't need to wait until you're at Series A and have a handful of employees, but these can be very useful even from the early stages as well. A company will also become subject to additional health and safety obligations. So I mentioned previously a health and safety representative, but after 20 employees are employed, that representative will need to turn into a health and safety committee. In addition, there'll be more accessibility obligations that a company needs to pay attention to, pay equity obligations, and so on. And as Catherine mentioned, at this stage, a company should really be looking to transition to a more professional employment framework, potentially hiring a designated HR designate, and just being proactive about its HR and employment needs. Of note, and again, this is also something that can come up early, but potentially at this stage, as there are more employees, a company might be looking to introduce other types of incentives for its employees beyond equity. This can include bonus plans or commission plans, for example. And while in large part these plans involve setting out the metrics and formulas through which incentive compensation will be earned, they really do need to be drafted with employment law compliance in mind. Since commissions and non-discretionary bonuses based on metrics are wages, there must be clear language dictating when they're earned. And just taking a little step back, as Catherine briefly mentioned in relation to the options, but essentially what the Ontario ESA says, and a number of the other provincial statutes, is that when employees are terminated without cause, they're entitled to their wages through to the end of their statutory notice period. And as well, unless validly limited by contract, employees can be entitled to various other aspects of their wages through to the end of any longer common law notice period they could be entitled to. So there must be terms addressing what happens to incentive compensation at termination. And without carefully drafted and unambiguous language that restricts the entitlements to receive wages to just the statutory notice period, to the exclusion of the common law notice period, the company can be exposed to paying quite large incentive compensation bonuses sometimes after an employee's departure, which is not desirable and can be a risk factor to investors.
Thanks, Maggie. I'm going to jump in here and just note very briefly for the audience that if this is the point in time at which your company starts to hire people outside of your given province, let's say Ontario in this case, You're going to need to also think about jurisdictional issues with your other employees. That might mean different forms of employment agreements. It might mean a national form of employment agreement, and it's going to mean adhering to legislative requirements in those other provinces as well. Moving back over to the corporate side of things, Heather, what do companies need to know about completing a Series A and moving towards a Series B from a corporate law point of view?
Yeah, so at a Series A, Series B, and so on, the corporate complexity increases significantly in proportion to however many number of investment rounds you do. At this stage, the investors are quite sophisticated. Often they're institutional investors, and they can bring both significant capital as well as significant expectations about how the company is run. So, similar to the seed financing, a Series A or B would introduce a new class of preferred shares with their own set of economic and governance terms. So a key area of negotiation here is the interplay between the seed preferred shares, which already exist, and the Series A preferred shares that are being implemented. Typically, last in, first out. So the Series A preferred shares would rank ahead of the Series C preferred shares in a liquidation scenario, meaning that the Series A shareholders would get their 1x participation preference before the seed investors are entitled to get their money back, and then again before the common shares. Corporate governance also becomes more structured at this stage. The board will typically expand in size, while at the same time, depending on what the investments are looking like and how many institutional investors are putting money in at a Series A, early investors may be required to give up their board seats, or more likely the common shareholders lose a seat as well. And so founders need to think carefully about board composition at this stage, because the governance dynamics of, let's say, a 5 or 6 person board with investor representatives are meaningfully different than a 3-person founder controlled board. Last, if the company is using the capital that it's raising to expand into new jurisdictions, whether interprovincially or internationally, across the border is very common these days, particularly with tech companies. There are corporate structuring questions to address. So should the company, for example, establish a subsidiary in whatever jurisdiction it's expanding into? Should it simply register to do business extra-provincially? Etc. And so these considerations at the structuring and expansion stage have implications for liability, tax, corporate structure, and governance. And so there's lots more to consider as the company grows ultimately, and that will continue as you move forward into Series B, C, and so on.
Thanks, Heather. Have you got any observations on how the corporate governance changes at Series A or B interact with employment matters from your perspective?
Yeah, so I think, I mean, it's interesting too when, like, for example, if a founder loses their spot on the board, let's say there's a 3-person team of founders that started as directors and they move off the board, they'll typically resign from the board. Whether or not they keep their officer position, I think would have significant employment considerations. Typically, I think the board wouldn't interact with their employment relationship, but I would be interested in your comments on that. But it can really, it also, like, I think it's good for the company overall too to have some external parties. There does become some conflicts of interest when a board is entirely represented by management. And people that are working for the company, people that founded the company. And so that can really help with corporate governance overall.
Thanks. That's perfect. So from here on in, of course, we'd be heading towards exit strategies for the post series, and then exit preparation as you head towards mergers and acquisitions. And of course, again, we're going to be discussing that in more depth at our webinar this autumn. We don't have a lot of time left. Before I check to see whether there are any questions, can I ask each of you for one key takeaway? Perhaps starting with you, Sean.
Yeah, so I mean, I think one key takeaway is to keep your corporate house in order from day one. So every resolution that isn't passed, securities issuance that isn't documented, any cap table discrepancy that you leave unresolved will all surface during due diligence. So the cost of getting it right early is trivial compared to the cost of remediating those failures at exit. Or even in a worst case scenario, if some of those issues can't be fixed later, you might render your business uninvestable or ultimately unsellable.
Thanks, Sean. I suspect that if I ask Maggie the question, the same takeaway question, she's going to have a similar answer. Maggie?
You're exactly right. The takeaway is it's almost exactly the same, but from an employment perspective. Put simply, employment law compliance should start at incorporation, and just evolve as the company grows. Each financing round will bring heightened scrutiny, and so having your employment affairs in order from the start will make you very desirable from an investment perspective and save you a lot of headaches down the line.
Thanks, Maggie. I see that we've got one question that's come in, but we've only got a couple of minutes left. I don't know whether this is a 2-minute answer, Sean or Heather. If it's not, we will get back to the person separately. What are we talking about here? 1-minute answer, 2-minute answer?
Yeah, I can try to answer it in a minute. So, question
I'll-
was how are option plans administered by the board? Um, and are management recommendations, whether for management itself or non-management to the board, a red flag? Or a red flag only if recommending for management itself. So I don't think it's a red flag at all. I think the purpose of management is to oversee the day-to-day activities of the team and ensure that the team members are being appropriately compensated and their compensation reflects the growth of the business. And so if you're recommending manage an option grant to yourself to the board, I think you'll have to stand behind the defensibility of that, and that might lead to whether you have enough so-called stake in the game or not at that point. But it's certainly not a red flag, and it's common for CEOs to be topped up with options to ensure their incentives align with the growth of the business as a whole.
Great, thank you, Sean. And with that, we've got about 30 seconds to spare. I want to thank everybody very much for attending today. It was really a pleasure for us to be able to speak with all of you, and thank you very much. I hope everybody has a terrific day. Take care.